The timeframes described in this timeline set forth the general sequence of a simple and typical Utah divorce action that goes to trial. Now, unique and special circumstances, applicable rules, or situations could and likely would alter the timeframes or steps shown here. So this video does not reflect what happens in all cases, but does illustrate generally what you can expect if you're not dragging your feet through the process. Note, Utah law, specifically Utah Code Section 30-3-39, requires that a divorcing couple participate in at least one session of mediation before the case can proceed to trial, although this mediation requirement can be waived for good cause if the director of the dispute resolution program for the courts can be persuaded to conclude that mediation should be waived. Waiver of mediation rarely occurs, so you are typically better off giving mediation a try, even if it's only for the purpose of ensuring you've met the requirement. Mediation can last for several hours or over the course of several days, depending upon what the parties choose to do. If mediation results in you and your spouse reaching an agreement and settling all of the issues, then it is not uncommon for your divorce action to be completed quickly. You and your spouse prepare and sign a settlement agreement and a stipulated divorce complaint, file them with the court, and then draft and file with the court the documents needed to dispose of your case. Once the court receives proof of your settlement and all the documents the court needs to issue your decree of divorce, it is not uncommon for everything to be turned around in just a few weeks. If you and your spouse do not agree upon the terms of your divorce, and one or both of you feels it necessary to go to trial and have the judge decide some or all of the contested issues in your divorce action, then this is how the process of preparing for and going to trial in your divorce case can and we believe should progress. We're going to describe how we do it at my firm on a week-to-week basis. Week 1. Meet with your attorney. Provide information needed to prepare your pleadings. Week 2. Prepare and file your complaint for divorce. Next, service of process. Serve the opposing party with a summons and a copy of the complaint for divorce. Service of process usually takes about a week, but can take longer if the opposing party evades service. You must serve the summons within 120 days of filing the complaint, or your case can be dismissed. Weeks 2 through 5, well, now within 21 days of being served the summons and a copy of the complaint, or 30 days if you serve the opposing party outside the state of Utah, the opposing party must respond to your complaint after being served with the summons and a copy of the complaint. Usually this response takes the form of what is known as an answer to the divorce complaint, or in most cases, an answer and counterclaim. If the opposing party files a counterclaim against you, you have to respond within 21 days of being served with the counterclaim. Week 6. If a party fails to respond to a complaint for divorce or a counterclaim within 21 days of being served, or within 30 days if the opposing party was served outside the state of Utah, the opposing party is known as being in default, which means that the opposing party has failed to respond to your complaint for divorce within the time permitted. That allows you to seek judgment against the opposing party for failure to respond and to participate in the action. This rarely happens, and even if you apply for default judgment and obtain it, if the opposing party moves to have your default judgment set aside in a timely manner so that the case can be heard and decided on the merits rather than by forfeit, courts will often set aside the default on that basis. Still, don't let that give you the idea that you can ignore court deadlines. Week 6 through 8. Prepare your financial declaration and initial disclosures and serve them upon the opposing party. The opposing party has 42 days after the service of the first answer to the complaint, or 28 days after the opposing party's initial appearance in the action, whichever period is later. Week 9. This is the discovery period. At least that's when it starts. Discovery is the process by which the parties, through the rules of civil procedure, can obtain evidence from each other and from other witnesses and other sources. Discovery tools include interrogatories, requests for admissions, requests for production of documents, depositions, mental health examinations, custody evaluations, vocational assessments, and subpoenas, to name some. Under the rules of civil procedure, this discovery period is 180 days long unless the court modifies the time period for discovery. Rarely, if ever, is discovery shortened, although it can be, and frequently discovery is extended beyond the 180-day period. Now let's jump ahead to the end of discovery to week 35. At this point, the case should be ready to certify as ready to schedule for trial. If so, either party can file with the court a certificate of readiness for trial and ask the court to schedule a date for the judge and the parties to meet to make preparations for trial. Let's talk now about week 43 to 47. Trial is usually set about 3 months away, give or take, after the pretrial scheduling conference. So let's assume that now 3 months have passed and we're at week 48 in the timeline. that's when trial is held. Trials usually last around 2 to 5 days, although they can take longer depending upon how many issues there are to try and how complex those issues are. Week 49 to 53, or in some cases maybe 57, after the trial has been completed, the judge can take up to 60 days to decide the case, unless the judge obtains permission from the presiding judge to take even more time to render a decision. Usually the court reaches a decision within several weeks instead of 60 days. Week 54. After the judge decides the case, the judge will usually direct one of the parties to prepare proposed findings of fact and conclusions of law and a draft of a proposed decree of divorce. Now, after the opposing party has been served by the other party with the proposed findings of fact and conclusions of law and decree of divorce for review, if the opposing party finds anything in those proposed documents that does not comport with the trial judge's decision, they can file an objection and have 7 days in which to do so. Week 58. If the opposing party files an objection to the proposed findings of fact and conclusions of law and/or to the proposed decree of divorce, the other party can respond to that objection within 7 days. At that point, the proposed findings of fact and conclusions of law and the proposed decree of divorce are submitted to the judge for the judge to decide what the ultimate form of the findings of fact and conclusions of law and of the decree of divorce will take. Week 59. Assuming that the court gets back to you within a week or two, the court will then issue the final findings of fact and conclusions of law and the final decree of divorce. If either party or both parties feel that the judge's decision does not comply with the laws governing divorce, then either party or both parties may appeal the judge's decision by filing a notice of appeal with the Utah Court of Appeals, which notice of appeal must be filed within 30 days after the date of the entry of the decree of divorce. There's your divorce timeline if you go to trial. We hope you found that interesting and helpful.